Hi, good afternoon everyone. So I'm Tharika here again, an attorney at law. So I'm your CL4 lecturer. So I can see there is an audience of about 20 students. So there's one request for all of you, that is, if you have any question, just stop me and ask the questions, right? Because this is for you to ask questions and to clarify whatever you have. It doesn't necessarily have to relate to the area that I am discussing. It can be on any topic or any area which you need to ask a question on. So just stop me and ask that question, right? Because we are here to give you answers to the questions that you have, right? So before I start, so today I am going to discuss the 2024 paper with you, CL4 paper with you, the latest paper that you have to go through, and we assume that there will be areas similar to this paper, but could be areas that are similar to the previous other paper in 2023. So keeping that in mind, I will first give you an idea of how the paper is structured, because how the paper is structured is that you will get 10 questions as MCQs which you must answer. Thereafter you get another 4 questions in section 2. Again, these questions are compulsory, so you must answer them. So how the paper, the marks are given is that for section 1, for the 10 multiple questions, you get 2 marks each, and so it will add up to 20 marks. Then for section 2, which has 4 questions, you will get 10 marks each. So there will be 40 marks there. So thereafter, you get another 2 questions where you will get 20 marks for each question, right? So remember that you have to answer all these questions. It's a must, right? You can't leave out any questions. So I will give you a few tips which you should remember when you're answering the questions, right? So one is that before you answer the question, look at how many marks is given, right? So obviously MCQs, you have no choice. All the questions are given the same mark. So you have to answer that. But in section 2 and 3, there will be questions which will give you 2 marks. There will be questions which will give you 3 marks or even 4 marks, or it could be even 6 marks, right? So depending on the number of marks they have given, you have to write accordingly, right? So if they are going to give 2 marks, it will probably be a very straightforward answer, right? So you have to write, if they ask what are the types of directors, you have to say it's executive and non-executive, right? If they ask what are the types of companies that are there, you will have to say private companies and public companies, right? So very straightforward answer you have to write. But if it is for 4 marks or for 6 marks, right, you will be required to write a little more, right? A little more in the sense there will be, you will have to write at least a few sentences. For 4 marks, I would say you have to write at least 4 sentences, short sentences. It doesn't necessarily have to be very long sentences. So if it is a 6-mark question, you have to probably describe or explain or critically analyze, right? Look at the keyword in the question, right? So if it is to analyze, describe or critically explain, right, you have to write at least 5 to 6 sentences to get 6 marks, right? So this is how you should approach the paper. Look at the mark that is given, right? Then when you are answering the first part, always read the question, read the answers, right? There will be 4 answers for you. Read all 4 answers and mark the answers which cannot be the answer at all, right? So when we are discussing the questions in the 2024 paper, I will explain it further to you, right? So look at the answers, and if you can't find out the answer, go back to the question again, right, and see what they have asked again, because you are time pressured, right. So, you need to utilize your time in a very effective manner. So, to utilize the time effectively, you need to understand the question faster. If you understand the question faster, you can answer the question. Thereafter, in section 2 and also in section 3, mainly in section 2, you will not get lengthier paragraphs, right. The scenario or the problem question that they will give will have very limited information. So, you don't have a lot to read, right, very short description will be given. But after reading that short questions, right, the description in the question, go to the sub questions they have asked, because you are supposed to answer each of them. And if you feel you have to, you again have to read the question, it's fine, you can go back and read it again and then come back and answer the sub questions, that is fine. But in section 3, you will have lengthier paragraphs to read, right. Sometimes there may be words that you would not understand. It's fine, it does not matter, right. But what I would suggest you is, first read the sub questions they have asked, right. There will be various sub questions they would have asked. So, read them first and then go back to that lengthier paragraph, right. Go back to the lengthy paragraph and read, right, because then when you have an idea of what they have asked in the sub questions, it will be easier for you to pick up the answers, because sometimes the answers come from that lengthy question, right. And when you are reading the lengthy question, you can always draw a small diagram on the margin of your paper, because when you draw that diagram, you don't have to read that lengthy paragraph again and again, because they will, they will sometimes give you a little bit of a difficult scenario. There will be a person X, a person Y, another company called PC, then creation of another company called PM, something like that. So, different names will be given and different people will be given, and it will be difficult for you to grasp it the first time. So, do not get discouraged, right. These are very easier things to follow. If you follow these, you can answer the paper successfully and you can answer within the time given to you. And remember, for your paper, you can carry the Companies Act number 7 of 2007. I do have a copy of it. This is a little torn, right. This is the Companies Act, right. You can take this to the paper, to your examination, but make sure that you don't put any other notes inside the Companies Act, because and other thing is, now this act has, like, the sections are very difficult for you to read then and there and understand. So, make sure that you read these sections before and write a short, like, like marginal notes like these, right. You can write small marginal notes like this, which I have written like this on the side, it's fine. But do not put any other notes inside this and take, right. So, you can write like this, it's fine, okay. And so, since you are carrying the Companies Act, you are not necessarily required to write the section number, but if you write it at least 1 or 2 sections, it will show the examiner that you know the syllabus very well, right, and it will be an advantage to you. Okay. With those examination tips in mind, so another thing that I want to emphasize is, I know all of you guys, you all are focusing on the other, I would say, other subjects, of course, accounting and various other, financial reporting and so on. So, this is a subject where people don't focus, I would say, won't give a lot of time to understand and to study, which is obviously understandable. But what I would suggest you is that it does not matter whether you have studied the entire syllabus, but you need to know all the areas. But if you go through the past papers, you will see what are the highly tested areas, right. So, the highly tested areas are basically they will ask about the types of companies, right. They will ask you about the directors, right. What are the types of directors, what are the qualifications to become a director, what are the disqualifications where a director can be disqualified, right. Then also they can ask you about the dividend payments, right, the dividends, the distribution, right. You know, they will give a scenario and ask you whether the shareholders can be given a dividend or not, right. Then obviously another highly tested area is about they will give you a decision and ask whether this require a special resolution or an ordinary resolution to be passed, right, and what is a special resolution. So, it is 75% of shareholders should pass the resolution for it to be a special, since if it is a special resolution, right. So, what is a circular resolution? They can ask that as well, right. And they also test you all on companies limited by guarantee, basically the companies which are there, which have been incorporated for voluntary purposes, right. So, remember that as well, and they and another highly tested area is on articles of association, right. So, how the articles of association have evolved from the previous act in 1982 and what has happened in 2007. So, taking away of the ultra vires concept and the objects clause being taken out from the articles. So, these are some of the highly tested areas, right, and also they will question you again. Two other areas, important areas are, one is on the listed companies, right. They will ask you if a company is listed in the Colombo Stock Exchange, what are the advantages, what are the disadvantages, right. So, you need to understand when can a company be listed in the Colombo Stock Exchange and what are the disadvantages of being listed, because obviously higher regulations would apply to a listed company. Then another very, I would say a very a pet area of your examiner is obviously the Foreign Exchange Act and also Land Alienation Act, right. So, when it comes to Land Alienation Act, they ask whether a person, especially a foreigner, whether a foreigner can purchase land in Sri Lanka or not, right. So, remember, under the Land Alienation Act, a foreigner cannot purchase land in Sri Lanka, cannot. So, if it is a company which has 100% foreign shareholding, that company cannot purchase land. So, if only the shareholding, if only the foreign shareholding is less than 50% only, that company can purchase a land or buy a land in Sri Lanka, because foreigners are prohibited from buying lands in Sri Lanka. So, remember that as well. And so, these are the highly tested areas in your syllabus. So, keeping that in mind, we will now look at the 2024 paper. Right. So, question number 1, they have asked which of the following provisions are applicable in relation to the law governing companies in Sri Lanka. Very straightforward question, I must say. This is like the basic question that they can actually ask, right. So, it is very simple. So, they have said first one, Company Special Provisions Law number 19 of 1974. So, there is nothing like that, right. Yeah. So, this is incorrect. This is obviously incorrect, right. Because Company Special Provisions Law number 19 of 1974, it's non-existent, right. There is no act or law as such. Then the Companies Act of 2007 of the United Kingdom. So obviously they are asking about Sri Lanka. So if it is about Sri Lanka and they have given a statute in the UK or in England, it's obviously not applicable to Sri Lanka. Then they have said the provisions of the Companies Act introduced after the repeal, right? They say after the repeal of the Companies Act number 17 of 1982. So what does repeal mean? Repeal mean that this new law, that is 2007 Act, was introduced, putting away, completely taking out the 1982 Companies Act, because 1982 Companies Act was the previous act that applied for companies before the implementation of 2007 Act, right. So this answer is correct, because it says, so provisions actually means the sections, right. The sections in the act is what they call the provisions, right. Provisions of the Companies Act introduced after the repeal of the Companies Act number 17 of 1982. So this answer is correct. So thereafter they say provisions of the Companies Amendment Act number 33 of 1991. So there is no such act, so that is also incorrect. So the correct answer is answer C, right. So then they ask in 1.2, the process of formally organizing and bringing into existence a corporate body is called incorporation. So I hope you all are familiar with what is incorporation, right. So incorporation is where you register a company, right. So to give a little background, when a company is being registered, right, first what you have to do, you have to first reserve the company name, right. So when you are reserving the company name, you have to use, if it is a private company, you have to use the term private limited. The company name should have private limited. So it can be ABC private limited, right, or else it can be, you can put the full term, right, as private limited, right, because they test you on this area, right. So when you are reserving the company name, you have to find a name which is not used by any other company, right. So it has to be something unique. So when you are first reserving the company name, you have to give this company name in Sinhala and also in Tamil, in English. You give it first, and when the name reservation is done, or when the name is approved only, you can thereafter incorporate the company. So to incorporate a company, you need directors, you need shareholders, and so those are the two main types that you need, right. So the directors can also be shareholders, that is possible for a private company. We usually say there should be at least 2 persons to start a private company, but in reality, you can register a private limited company with just one director who is also a shareholder, right. So to register the company, you have to give certain forms. You have to fill, the directors and the shareholders, they have to fill certain forms. So those forms are form 1, which has to be signed by the directors and the shareholders. Then there is form 18, right. I'll just write it down because they test you on this area as well. So for a company incorporation, there are certain forms that you need to submit. So those are basically form 1, which has to be signed by the directors and the shareholders. Directors and shareholders have to sign. Then there is form 18, which has to be submitted by, this is actually the consent of the directors right? This is for consent of the directors. So, each of the directors have to sign form 18. Then there is form 19. So, remember, a company secretary has to be there for each and every company, and it is a mandatory requirement, it is compulsory for companies limited by guarantee. Remember, I told you companies limited by guarantee are there for voluntary purposes. They have been established for charitable purposes mainly, right. So, a company secretary is a must for a company limited by guarantee. Then who can be appointed as a company secretary? So, a company secretary can be either can be an attorney at law, right, a lawyer, or can be someone who has passed the examination of examination in the chartered secretaries, right, company secretaries. So, they are called chartered secretaries, right. So, there are two types who can be company secretaries. Then form 19 is basically the consent of secretary, right, or company secretary. Then there is another document that you have to submit at the time of incorporation, and that is, the last one is the Articles of Association. So, Articles of Association should have certain information in that. So, this will basically have everything, you know, this is actually the constitution of the company, right. It will have information of how the shares can be issued, call of shares, then how the directors can be appointed, what is the maximum number of directors which can be there, how many is the minimum number of directors, how the directors are appointed, right, and what is the purpose of the company. Remember I told you the objects clause is not really required to be included in the Articles of Association, right. So, objects clause is not a must, right, but there is an exception to this, and an objects clause should be there in the articles of a company limited by guarantee, right. So, the objects clause is not necessary for the Articles of Association, but under the 1982 Companies Act, the objects clause was mandatory to be included in the articles, right. So, after you submit all these along with the stamp duty that should be paid to the registrar of companies, right. So, you submit all of this to the registrar of companies, right. When you submit this to the registrar of companies, they will see whether all the requirements are fulfilled, right. If everything is fulfilled, then obviously the company will be incorporated by the registrar of companies. Okay. So, keeping that in mind, so remember at the time, now when you incorporate a company, the company becomes a corporate body, right. It is called a corporate body, right. So, after incorporation, the company is created, right. So, this company is a corporate body, right. So, what is a corporate body? A corporate body is, it is a body which can be sued and can sue in its name, right, and it has a separate legal personality, right, compared to its directors and shareholders, right. So, that is what happens at the time of incorporation. So, corporate body is something which can be sued or sue. It can, the company can file a case against anyone, right, and anyone, any person in the public can file a case against the company in its name, right, sue or sued in its name, right. So, that is what this incorporation gives, right? It gives separate legal personality, right? So, I hope you remember, when this separate legal personality is there, the directors and the shareholders will be considered separate from the company, right? And there will be a separation of these, a separation between the directors and the company, which is done by, or which happens by, the veil of incorporation, right. So, when there is a veil of incorporation between the company and the directors or the shareholders, the liability that will come to the shareholders or the directors at the time of liquidation, or whenever there is any issue against the company, will be limited, right. But always the court can lift this veil of incorporation and see who is behind the company, who is behind the management of the company, right. So, that actually happens if the directors or even the management has engaged in any type of illegal activity or any type of misconduct, or they have taken a decision which is against the interests of the company, right. So, that is how this incorporation affects the company and its directors or the shareholders, right. So, with that in mind, we will go back to the question, because the reason why I am explaining this, the basics that you should know, is because knowing these basics is important, right. Without the basics you can't answer, especially the MCQ questions, but if you know the basics, you can obviously answer the paper very well, right. So, let us look at this question now. The process of formally organizing and bringing into existence a corporate body is called incorporation. Even as there are many benefits of incorporating a company, there are also disadvantages. So, they are asking, what are these disadvantages of incorporating a company, right. So, what do you think the answer is, right. So, first one, it says, its independent corporate existence results in its owners acquiring a corporate legal personality. So, do you think whether it is a disadvantage or an advantage, right. So, they are basically saying its independent corporate existence. So, this is that corporate legal personality results in its owners acquiring a corporate legal personality. So, actually it is a good thing, because who are the owners of a company? It is the shareholders, right. So, having that corporate separate legal personality and the veil of incorporation would be good, because otherwise they can be held unlimitedly liable, right, for whatever that happens in the company, right, which can be a if the separate legal personality is not there, then it will be a disadvantage, right. So, then if all its initial shareholders transfer their shares to outside parties, the company loses its right of perpetual succession. So, is this true or not, right? Obviously, a company has perpetual succession. So, whoever who leaves the company, whoever who resigns, whether it is a director or a shareholder has sold all its shares, it does not matter, because perpetual succession is obviously there. So, even if all its initial shareholders transfer their shares to outside parties, the company will have perpetual succession. So, this is actually incorrect. The owners will have less control over a company when compared to other types of business structures, right. So, what are these other types of business structures, right? So, you may have heard of sole proprietorships, right, or else there are public companies as well, but they also have to be incorporated. So, even the sole proprietorships have to be incorporated, right, that is incorporated in the sense they need to get some approval, right, the Grama Sevaka, and then they have to produce the documents to the divisional secretary and get a sort of like a license to carry on their individual business, right. So, so actually in a sole proprietorship there will be more control that the owner will get over the business, right, compared to a company where the shareholders will have limited control over the functions or the business structure, because the shareholders will only be involved in some of the decisions, not on all the decisions, right. So, obviously, the owners will have less control over a company, because there will be directors, there will be other management, right. So, all those people will get the decisions and the actual owners will not have much say in the company's decisions, right. So, therefore, actually this can be taken as a disadvantage, but to be on the safe side we will look at D as well. As a company has perpetual existence, it becomes impossible to dissolve or liquidate it. That is not true. A company can be wound up, it can be dissolved or it can be wound up, and a company can go into liquidation anytime. That is also possible. So, this is actually untrue statement. So, see, even though they have asked about the disadvantages, you will assume that they will give advantages, not necessary. They are sometimes given untrue statements as well. So, obviously, untrue statements which are not true or which are wrong can't be taken as the answers. So, this is incorrect. The correct answer is answer C, right. I hope that is clear to all of you. If you have any questions, please ask, right. So, let us look at 1.3. Which of the following statements is correct in relation to shares of a company? So, they are asking about the shares. Remember, there are different types of shares, preferential shares are there, ordinary shares are there, right. So, different types of shares are there. A company cannot issue shares having a ranking above ordinary shares. So, that is incorrect. So, they are asking the correct statement. So, when you are reading the question, right, you can always underline the keywords, right. That is something which you can do to ensure that you do not have to read the question again and again, right. A company cannot issue shares having a ranking above ordinary shares. So, that is not true. So, they can issue other types of shares such as preferential shares, shares which will give more preference to the shareholders, right. So, ordinary shares is like the minimum, minimum in the sense the type of shares that will give the minimum rights to the shareholders, the right to vote, the right to receive a dividend, right, those things. But obviously, if there are dividends declared, who will get more preference? Those who own preferential shares will get more preference compared to those who own ordinary shares, right. Then they say the basic form of shares is ordinary shares. So, it is obviously from the look of it looks correct, but let us see C and D as well. In a modern world the tendency is for companies to issue deferred shares. That is not true. Even this type of deferred shares is not necessarily what the companies will issue. They will issue ordinary preferential shares. Redeemable shares are issued on the understanding that they will be bought back by the other shareholders of the company. No, that is not true. Redeemable shares are shares that can be always bought back by the company, not by the other shareholders. They are bought back by the company. So, that is also incorrect. The correct answer is answer B. (1.4) So you see now, now from the look of it, you will see, okay, there's a little bit more to read, a little bit that you need to understand. But see, there you have to pick not just one correct answer, you have to pick several answers which will be correct, right. In Mr. Charlie's law class, right, probably a class like this, during a group discussion held, the students made the following statements in relation to the solvency test, right. They are talking about the solvency test here. So, obviously, solvency test is where, you know, the company should be able to pay out its debts, right. I think you all will know, like, solvency test, the equation, right, but obviously the gist of it is that the company is able to pay its debts. Okay. In determining whether a company satisfies the solvency test, the board shall take into account the past 5 years financial statements of the company, right. So, now, you know, you to satisfy the solvency test, there is actually no point in looking at the previous year's financial statements, because you have to look at whether the company is solvent or not in the current situation, whether the company is solvent or not currently. There is no point in looking at these, you know, past 5 year financial statements. So, this is actually incorrect, because to see whether the company satisfies the solvency test, you have to see whether the company is solvent at the moment or not, right. Then the next one, the circumstances the directors know which affect the value of the company's assets and liabilities must be taken into account in determining whether a company satisfies its solvency test. So, they are saying basically you have to see the company's assets and liabilities when determining the company satisfies the solvency test or not. So, that is exactly what solvency test means. You have to look at the liabilities and the assets of the company. It is mandatory to be looked at. So, this is correct. A company shall be deemed to have satisfied the solvency test if its stated capital exceeds its total assets at the time of determining the solvency. So, they are saying the company is considered as it satisfies the solvency test if the stated capital exceeds its total assets. Is it only assets? No, it has to be liabilities as well, not just total assets, it has to be the liabilities as well. So, this is incorrect. Next one, a company shall be deemed to have satisfied the solvency test if it is able to pay its debts as they become due in the normal course of its business, right. So, the fact that the company is able to pay its debts in the normal course of business is exactly what the definition of the solvency test. So, 2 and 4 are correct, right. So, the answer is C, right. Now, you can also, you know, this type of question you can go by the elimination method, because if you are not sure, now let us say for example, you are not sure whether 1 is correct or not, but you are sure that 3 is incorrect, right. So, if 3 is incorrect, you can eliminate B and D, then you are only left with A and C, right. When you are left with A and C, so 2 is there in both, so you have to see whether 1 or 4 is correct. So, you can go by the elimination method as well if you have a question like this where you are supposed to select 2 correct answers. Let us look at the next question, 1.5. The most accurate statement in relation to debt capital. So, they are asking about the debts, long term, short term debt, right. What sort of debt capital and what is the most accurate statement here, right. Debt capital refers to money raised by a company from outsiders and which must be repaid annually with interest. Not necessary, right? Sometimes, you know, the short term debt capital has to be paid before before an year is completed. So it can be, you know, less than an year, and it's not always, you know, paid annually with interest. Sometimes it can be just a one-off payment, right? So this is not correct, right? Debt capital is compulsorily long-term financing instrument. No, because there is short-term debt capital as well, right? Not always long-term. Sometimes it can be short-term, which is less than 12 months. Debt capital can only be obtained through banks and finance companies. Not true, you know, it is true, but not only from banks and finance companies. You can obtain debt capital by, you know, it can be even individuals, right? It can be even, you know, other types of debt as well. So not always banks and finance companies, right? Then next one, debt capital can be both unsecured as well as secured. Yes, that is correct. It can be, you know, secured where you where the company will have a security. It can be property, it can be a deed, it can be a house, a car, right? So that is secured where the company has a property with them before they give out money, or before they, no, they will keep something, you know, the company will keep an asset with the bank that gives them a loan, right? So when the bank is giving the company a loan, they might keep some assets. So then that is secured capital. If it is unsecured, then they have, the company has not given any asset to the bank that is giving the debt, right? So this is correct. So the correct answer is answer D. Let's look at 1.6. A certain type of company does not issue shares. Rather, in the event of such company's liquidation, its members agree to contribute to its assets at the sum designated in the articles. So this, it's not unlimited liability or limited liability. It says at the time of liquidation, the members, right, they have used the term members as well, agree to contribute to its assets the sum designated in the articles. So how the payments should be done at the time of liquidation, how how the members have to pay when there is liquidation to the creditors is given in the articles. Remember which company's articles is the most important. It is the company limited by guarantee, right? And there is no set method of how a company limited by guarantee is governed. Usually it's always governed by the articles or articles of association. So whenever they say articles, it means the articles of association, right? So I mean, if it is a limited company, private limited company, the members are limitedly liable. It's a given, right? Unlimited, I mean, there are no unlimited companies, but if it is unlimited, then the members are unlimitedly liable. They have to even sell their assets and pay out the debts. But here they are talking about an instance where the contribution to the assets will depend on how much that is mentioned in the articles, right? So what is the type of company referred to above? Is it a listed company? No, it is not. A single shareholder company? No. An offshore company? No. The answer is answer D, a company limited by guarantee. So whenever they say that there is distribution of assets according to the articles of association of the company, or there is a resignation of a director based on the articles of the company, a director is appointed based on the articles of the company, right, and the there is an objects clause in the articles. So, all that will relate to a company limited by guarantee, right. An offshore company is obviously a company which has business abroad. A single shareholder company, again that one shareholder will be unlimitedly liable, I suppose, because there is only one shareholder. A listed company obviously will be governed by the CSE listing rules, and they can't decide based on its articles. In 1.7, so this is obviously one of the areas that I mentioned, highly tested areas, right. Which of the following statements is correct in relation to the inward investment accounts under the Foreign Exchange Act number 12 of 2017. So, inward investment account, and there is another type, that is outward investment account, right. So, if it is an inward investment account, the foreign currency, let us say USD, will come to Sri Lanka, right. It comes to Sri Lanka. The foreigners, or it could be even locals, they will send foreign currency to Sri Lanka. But if it is an outward investment, right, the currency, foreign currency, let us say USD, will go out from Sri Lanka to another foreign country, right. So, this is how it works. So, these inward investment accounts and also outward investment accounts, you can open them in the central bank, right, and these accounts are governed by the Foreign Exchange Act number 12 of 2017. So, this is an act that has come about after the Companies Act, actually much later than the Companies Act. So, they are asking what is the correct statement regarding the inward investment accounts. Answer A, IIAs are special accounts designated for eligible investors resident in or outside Sri Lanka to route funds to invest in permitted investments in Sri Lanka. So, is this statement correct or not, right? So, they are basically saying eligible investors which are resident in or outside Sri Lanka. The key phrase here is route funds to invest in permitted investments in Sri Lanka, right. So, they are going to route funds in the sense send funds for investments in Sri Lanka, right. The within Sri Lanka only the investments are happening, right, and it's not necessarily, inward investment account doesn't necessarily have to be opened by foreigners or those who are outside Sri Lanka, not necessary, right. They can be, within Sri Lanka. Obviously, to open the account they have to come to Sri Lanka. So, this term resident, right. So, actually a resident is decided how it is in the Sri Lankan law is that any person can be a resident of Sri Lanka if he has stayed in Sri Lanka for more than 6 months, right. But it's not necessary for an investor to be within or out, an investor to be out of Sri Lanka, can be even inside Sri Lanka. So, there are enough and more foreigners who come to Sri Lanka, right. They are not resident here, they just come here, do the investment and then they go back, right, and then they route funds outside from Sri Lanka to Sri Lankan banks. So, that is how it works, right. So, from the look of it, it seems correct, but let us look at the other 3 answers as well. So, second one is money which meets the definition money laundering can only come into the legitimate cash flow of a country if deposited through IIS. So, actually this money laundering if I give you a brief idea of what it is. So money laundering is actually, it's a crime, right? You can't open up an inward investment account to, to route in illegal money which you have earned to Sri Lanka, right? Probably it is being used by some of the investors as a method for money laundering, but what they have stated here, money which meets the definition money laundering can only come whenever they use the term only. Remember, most of the time it's incorrect, right? Because only means there can't be any other options, right? So whenever there is this term only, just look at the question again carefully, right? Because this is a very tricky word that they give you. This is something which they use in, even in, in law, basically, mostly in law, to confuse the student, right? Because if you don't read the word only, it will give a different meaning, right? So money which meets the definition money laundering can only come into the legitimate cash flow of a country if deposited through IIS. Obviously that is incorrect, because money laundering actually, it doesn't necessarily have to come from IIS, it can even happen within the Sri Lankan territory. No exemptions are given to persons resident outside Sri Lanka when they deposit money into IIS. So they are saying no exemptions, right, are given to persons resident outside Sri Lanka, right. So obviously, most of the time this money that comes from IIS, or whenever a foreigner is investing in Sri Lanka, they get lot of exemptions. It can be tax exemptions if they are doing a foreign direct investment, because if they show the project, if they provide the project proposal and get approval, then of course they get a lot of exemptions, right. So exemptions are obviously there for foreigners if they are investing in Sri Lanka. So persons resident outside Sri Lanka means the foreigners. So when they deposit money into IIS, there are exemptions, right. So these exemptions and the word exceptions is two different things, right. Exemptions are, you get exempted, you are, sometimes some of you may have got exemptions when you were joining the chartered accountancy course, right. So you are exempted, you don't have to follow certain things. Exceptions is also little similar. Exceptions are where you are there is something which is against the general rule, right. That is what you call as exception, okay. So there are exemptions that are there for persons resident outside Sri Lanka when they deposit money into IIS, right. So this is also incorrect. So in Sri Lanka, IIS can only be opened at the central bank. Yes, in central bank you can open IIS, but there are other government banks where you can open IIS, even BOC you can open an IIA, right. So it's not only the central bank, you can open it in BOC and other government banks as well, right. So now see, from the look of it, obviously you see these three answers cannot be correct, right. So by the method of elimination, you can take this as the correct answer, right, because there is nothing wrong in the first answer, it is all correct, right. So the correct answer is answer A. Let us look at 1.8. So again, this you can go by the elimination method. They have given different options here, 2 options in each answer, right. So they are saying, out of the above, the documents that Z must submit as per the Companies Act in relation to this office opening would be. So I looked at the bottom part where they have asked exactly the question before I read the first bit. So now let us go back and see. Zealot Limited, an overseas company, intends to open a place of business in Sri Lanka. So they are talking about the overseas company, right. They want to open a place of business in Sri Lanka. Some documents that are submitted to the registrar of companies by companies under the Companies Act at different times would be as follows. So, they are asking what are the documents that an overseas company should submit to Registrar of Companies in Sri Lanka to start to open a place of business, right. So, remember there is a difference between overseas and offshore companies. So, offshore companies, they are incorporated abroad, right, they carry out business abroad, right, but overseas companies, they can have a place of business in Sri Lanka, right. So, what are the documents that you have to submit to the Registrar of Companies to open up a place of business, right? A certified copy of the company's constitution. So, the constitution here is the articles, a list of its directors. So, list of its directors, so obviously the directors' names is it's a must to give the company's Registrar of Companies. Its annual return. So, annual return, it's actually, you have to submit form 15 for annual returns, right. Annual return is usually form, it's actually the form 15 for all the private companies, or it's form 15A for companies limited by guarantee. Form 15A, right. Annual returns, of course, it's not necessary to be submitted at the time of starting a place of business in Sri Lanka. Usually annual returns are given thereafter, right, probably after the first 12 or 18 months. Its latest share form issue, right. So, now you see you have to pick 2 of these, you can't take all 4, right. So, now see, if you put out 3, right, you can eliminate these 2 because obviously annual return you do not have to. Its latest share issue forms. So, they are saying, usually when there is a issue of shares, you have to submit form 6, right, if the number of shares have increased, right, at a share issue you have to give the form 6. So, that is also not necessary, it is not a necessary document, right, but these 2 are obviously very necessary, right. Even when you are incorporating the company, remember I told you form, the consent of directors by way of form 18 is a must, they have to sign it off, right. The company's constitution again is a must because it is the basic document that has all information about, about the number of about all the information of the company. So, obviously 1 and 2 are the correct answers, right. So, the answer is answer A, right. So, this you can eliminate, this also you can eliminate, then you have to see whether you can take 2 and 4. So, 4 again is incorrect. So, the correct answer is answer A. Then 1.9, they are again asking about the companies limited by guarantee. So, you see it is a pet topic of your examiner, companies limited by guarantee, right. A minimum of 2 people may apply for the formation of such companies, right. So, that is actually correct. Remember I told you there should be a minimum of 2 members to start a company limited by guarantee, or even a private company there should be minimum of 2 people. They are used only for incorporating charitable organization as corporates. Yes, for charitable purposes you can incorporate a company limited by guarantee, but they have used the term only here, right. So, it is company limited by guarantee doesn't, it is not only for charitable purposes, right. Sometimes they can be NGOs, INGOs, right, the non-governmental organizations, not always charitable, right. So, can be any other type of organization as well, but usually yes charitable, but whenever they use the term only, remember it is most of the time the answer is incorrect. right. Its members are entitled to receive dividends only at its liquidation and not before that. So, again remember, the members of a company limited by guarantee will not get dividends. Whatever the profit that they earn, if at all they earn a profit, they have to again give it back, give that profit back to the company, or they have to invest again in the company. So, this is also incorrect. Articles of association are not necessary for the formation of such companies. Absolutely incorrect, because articles of association with the objects clause, right, with the objects clause is a must for companies limited by guarantee. Yes, objects clause is not there anymore. You don't need to have an objects clause under the articles of association, but still, practically speaking, whenever you go to incorporate a company limited by guarantee, they will look at the objects clause. They will see what is the purpose of incorporating the company limited by guarantee, right. Because the registrar of companies is a little strict when it comes to the companies limited by guarantee. Okay. So, the correct answer is answer A. So, 1.10, they are asking about the outward investment account. Which of the following statements is correct in relation to outward investments account, outward investments or outward investment accounts under the Foreign Exchange Act number 12 of 2007. So, if they ask you what law governs the outward investments accounts or inward investments accounts, the answer is Foreign Exchange Act number 12 of 2017. So, it is easy to remember because the Companies Act is in 2007. So, right after 10 years from there on, in 2017, Foreign Exchange Act has come into being. So, let us look at the answers. So, they are asking what is correct. OIAs are a business strategy used by overseas companies to expand their overseas operations. So, yes, it is part of it, but not really the only method used for expansion of the overseas operations. So, looks correct, but not 100% correct. Let us look at the next one. OIAs are special accounts designated for persons resident in Sri Lanka to channel funds abroad for eligible overseas investments. Yes, this is where the money goes from Sri Lanka to outside, right, from Sri Lanka to abroad, right. That is what an outward investment account is, right. Licensed commercial banks are permitted to open and maintain OIAs in the name of non-resident investors. So, no, not licensed commercial banks, it is the state banks, right. OIAs in the name of non-resident investors, that is incorrect. The law does not impose a limit on the amount of outward investment that can be made through an OIA in one given time. Know that there are limitations. Obviously, when there are because USD is going out of the country, right, it goes out of the country. So, whenever there is a shortage of US dollars in Sri Lanka, right, which actually happened during the economic crisis and which has been happening for some time even now, there will be restrictions or there will be limitations or restrictions on how much of currency of US dollars can go out from Sri Lanka to another country. So, the correct answer is answer B, right. So, let us go to the next question. Rather the next section. So, again remember, all the questions in this section are compulsory, right, and each question will carry 10 marks. So, 4 questions, 40 marks. Okay. So before we go to the question, look at how they have allocated the marks, right? So obviously you have to write more for part A compared to part B, right? So they are asking with reference to a decided case whether BM can succeed in its proposed action. So you need to write a case here, which I will tell you which case it is. Whether DS is permitted by the Companies Act to file such action, right? So now let's look at the scenario. Harry was a former CEO of Broad Motors Limited. So you can draw like a small diagram, right, on the margin of your paper, because you don't have to read these over and over again. So something like this, right. So CEO H, right, and was the former CEO, right. This is the previous CEO of BM. His employment contract prevents him from soliciting BM's customers. Soliciting means, you know, you take new customers. So you take the previous customers that were there in the other company to your new company. That's what you call as as soliciting customers. Subsequently, H resigned from BM and incorporated Mats Private Limited, right, MPL. So now H has resigned from this and he has started MPL, in which H owned 90% of shares. So he owns 90% of shares, whilst Damit Soisa DS owned balance 10%. MPL solicited BM's clients without the knowledge of DS, right. So DS had no clue that MPL was soliciting BM's clients. BM is considering filing legal action against H individually, claiming that MPL was an attempt to evade a legal obligation of not soliciting customers by H, right. So who's going to file action against who? BM, right. BM is a previous company of H who's going to file action against MPL. For what? For soliciting BM's customers, right. Now who's actually soliciting the customers? It's H, because he owns 90%. DS has not had any idea about the soliciting of customers, right. So and remember, H has employment contract, right. It basically had a clause which said that H cannot solicit customers of BM. So obviously, you know, there are especially for salespersons of companies, there are clauses in their employment contract or the letter of appointment itself which says you can't, right. Basically you can't you can't solicit customers of that company if you have left the company and started a new company or something like that. Sometimes there are restrictive clauses which prevents or which stops an employee from joining a competitive business or a competitor, right. So with that in mind, let's and also they are asking whether DS, who is a 10% shareholder, remember DS is only a 10% shareholder, whether he can take an action against MPL, right. MPL is the current company where he has only 10% of shares for mismanagement, right. What is mismanagement? Mismanagement is a remedy, mismanagement, operation, minority buyout rights, derivative action. All these four are remedies that are available to shareholders whenever there is a decision taken by the company or the company's directors or even by the other shareholders against the best interest of the company, right. Whenever there is a decision which has been taken against the interests of the company, then a minority shareholder who has about 5%, at least a minimum of 5% of shares, can file action in court against the company, right. So now what do we have to do, right? They are saying with reference to a decided case whether BM can succeed in its proposed action. Now, BM wants to take action against MPL for what? For soliciting its customers. So, to see who has actually solicited customers, they know that it's H, right, Harry, who was the previous CEO, right. To find out who has done this, right, to show that it was H, right, you have to do what? The court has to do what? The court has to lift the veil of incorporation which is in between MPL and H, right. So, obviously, when MPL, now remember I told you there is separate legal personality between a company and its shareholders, right. So, here it is H who is the 90% owner of shares, right. So, to lift this is the veil of incorporation, right. To lift this veil of incorporation, BM has to file action in court and the court has to lift this veil of incorporation and see who is behind the company ML, who are the real owners of the company ML, who is the mastermind behind the soliciting of customers, right. So, the relevant case law for this is Guilford Motor Company Limited versus Horn, right, Horn. This is the relevant case law for lifting the veil of incorporation, right. So, what you have to basically say is, when you get this question, you have to say, right, the facts discussed in this scenario at hand is similar to the facts that were discussed in Guilford Motor Company Limited versus Horn, right. And this case is relevant for the concept of veil of incorporation. So, in this scenario, if BM wants to see who is the real culprit or who is the actual owner of MPL, the veil of incorporation which is in between MPL and H should be lifted, right. So, lifting the veil of incorporation is the way that they can find out who is the person or who is responsible for soliciting customers of BM, right. So, by applying this rule, they can succeed in its proposed action, right. So, that is what you should write for 6 marks. So, when you write this case law, obviously you will get about 3 marks. So, the rest of the 3 will come for you, the marks will be allocated for your explanation. Then the next one, whether DS is permitted by the Companies Act to file action, whether DS is the minority shareholder. So, the answer is yes, the action can be filed by DS. And what is the action that can be filed? He can file an action against the company for mismanagement. So, action is mismanagement, and to file an action against for mismanagement, the minimum number of shareholding should be 5%, but DS has a percentage of 10% of shares in the company. So, therefore, he can file an action in court for mismanagement. So, the relevant section is section 224 of the Companies Act, right. Sorry, 225 of the Companies Act. So, the relevant shareholding, that is 5% is stated in 226 section 226. Okay. Let's go to the next question. Since we are a little time pressed, I will go to the next one. So, here they are asking, right, there are 3 parts, 4, 2 marks, right. Let us look at the question. Aluminium Industries PLC is a listed entity in the Colombo Stock Exchange. AIP intends to take the following decisions related to its new market expansion policy. First one, to merge with another aluminium supplier company. So, they are talking about a merger, declare a final dividend of 100 rupees per share for the year. Then the next one is a new strategic plan for the proposed business expansion of the company, to recruit a new technical officer from India for the proposed new factory of the company. So, they are asking what is the price, what is price sensitive information, what do you mean by price sensitive information in relation to the listed securities of AIP, right. So, what is meant by price sensitive information is where, now since this is a listed company, so any decision or any information of the company that will affect the market, that will affect the securities market, right, the demand and supply of the securities market, right. Because when some information is released to the, when it becomes public, right, basically some price sensitive information should be disclosed to the public, that is the most important thing. So, some of these information should be disclosed to the public, price sensitive information, because this information can affect how the shareholders, whether they will buy the shares, whether the public will buy the shares or not, whether they will sell the shares or not, right. So, that is what you call as price sensitive information, right. So, in your syllabus they have said the marking scheme has basically said the term price sensitive information refers to information which relates to specific matters relating to directly or indirectly to AIP. So, it has to be information which directly relates to AIP and which is not generally known by the public, but should be disclosed to the public, right. Because if it is known to them, then whether the shareholders, whether the public will buy the shares or whether they will sell the shares will be determinant on this information, right. So, here, so that is the answer for what is meant by price sensitive information. So, then they are asking, explain whether proposed decisions of AIP fall within the meaning of price sensitive information. So, here you have to see out of these 4 what falls under price sensitive information. So, when there is a merger, yes, it is a price sensitive information because it can affect how people will invest in the company, whether the shareholders want to be, whether the public wants to invest in it or not. So, a merger, it is a big change that will happen in the company, right. So, obviously, it is a very high price sensitive information. The declaration of dividends, again it is a price sensitive information because it is in relation to how the company has functioned so far. It shows actually the company has done a good job because the dividends will be declared. Then what about this strategic plan and technical officers? These are not actually price sensitive information, they are very management based decisions, right. They are strategic decisions that the company is taking for the betterment of the company, right, not necessarily price sensitive information. So, the correct answers are this one and this one, you have to write those 2 here. So, they have given 4 marks for that. Then the next one is explain per the listing rules of the CSE what AIP should do in relation to price sensitive information. So, I have already told it to you, it is where they have to disclose this information as per rule 8 of the CSE listing rules. It's under rule 8, right. This information which is price sensitive has to be disclosed to the public, because how the public makes decisions will depend on this information, right. Let's look at the next question, question number 4. State, Fab Freight Movers Private Limited is a company incorporated under the Companies Act. At its last board meeting, the board was of the view that the company will be unable to pay its debts as they fall due. So, this is an important part where it says it's board meeting. So, the board of directors were of the view that the company will be unable to pay its debts as they fall due. So, the company will not be able to pay its debts. So, there is a issue of solvency here. They considered appointing an administrator, right. So, an administrator is usually appointed at the time of winding up of a company, right. Amal for the preparation, so Amal is the administrator for the preparation and approval of a compromise or arrangement under the Companies Act. So, they are going to see how they can sort out this lack of solvency issue. Mr. Pandita, one of the board members, expressed certain instances specified in the Companies Act that do not allow for an administrator to be appointed. So, there was some intelligent person in the board who has said how, who has said that sometimes the administrators cannot be appointed based on different reasons and based on the situations, right. So, they are saying first one you have to explain, you have to state basically, you have to state 7 powers and duties applicable to Amal. So, they are asking the powers and duties of the administrator in this situation. Right. 7 duties and powers applicable to Amal. So, Amal as the as the administrator has the duty and the power basically to manage the affairs, the business and the property of the company. So, he is going to be like a third party, like somebody who is going to give a solution to the issue that the company faces, because the company has to pay out the debts to its creditors, right. So, administrator is somebody who is being appointed for that purpose. He is like the mediator between the company and the creditors, right. So, he will do all the necessary things which needs to be done for the amicable settlement or an agreement between the creditors and the company. So, you can say first one to manage affairs, business and property of the company. Then the second one to do all such things as necessary and desirable for the management of the company. Then third one would be power, he will have the power to be exercised by the receiver. So, he receives all the power to be exercised in relation to how the property needs to be dealt with, and he takes an undertaking that he will act for the benefit of the company to further the interests of the company, right. And upon his appointment, he will be the custodian. He will take custody of the company's all property and whatever the properties that the company seems to be entitled, right. So, he has to act in accordance with the provisions of the Companies Act. So, that is one of his duties, right. And he will have to summon a meeting of all the creditors of the company and if directed, he has to do so by court. So, basically there are powers and duties. So, powers is basically to manage the, so he will become the custodian, right. custodian of all the properties of the company, and he has the duty to manage properties, right, affairs, right, affairs, creditors of the company, right, and if required he has to refer the matter to court as well. Then the next one, state 3 such instances that Mr. Pandita was referring to. So, Mr. Pandita was referring to instances where an administrator cannot be appointed. So, when the administrator cannot be appointed are basically whenever there is an order for winding up of the company, because if there is already an existing order for winding up, you do not need an administrator to deal with the creditors, because already the court has taken a decision for winding up, right. And also if there is a receiver who is already appointed by the company, then an administrator is not required. So, a receiver is also more or less like an administrator, but he will be most of the time he is appointed by the court, right. So, you do not need a separate administrator. Then the next one is an administrator, also the court can appoint an administrator, not only a receiver but also an administrator can also be appointed by the court. So, whenever there is an already appointed administrator or an appointed receiver, right, for the whole of the property, then you do not need an administrator to administer the property, because already there is a receiver who is going to get the property. And the last one is when the company, when there is an order to wind up the company already, you do not need the an administrator to deal with the creditors, because already an order is there for winding up, right. Let us look at the last question in section 2. Calligra Company Private Limited is an overseas company registered under the Companies Act. CC operates a hotel chain in Hikkaduwa. Hans David is a British citizen and is the managing director of CC. H is also the sole shareholder of Hans David, a company incorporated in Sri Lanka. H, who fell in love with Hikkaduwa, is now interested in purchasing a land in Hikkaduwa. H is considering purchasing this land either in his own name or in the name of HDPL. So, who is H? He is a British citizen. So, remember, you have to remember what comes here is the Land Alienation Act, right, what is applicable here. Land Restriction on Alienation Act, actually it is an act which came about in 2014, right. Land restrictions on alienation. Alienation basically means selling, right. Restriction on Alienation Act, right, Act number 38 of 2014, right. So, now he is a foreigner, he is not a Sri Lankan citizen, right. So, remember what I told you, foreigners cannot sell land or buy land in Sri Lanka, right. Even a company which has more than 50% of foreign shareholding cannot purchase land in Sri Lanka. So, they are asking, now you have to explain to H whether he could purchase this land as intended by him, taking into consideration the restrictions imposed by the Land Restrictions on Alienation Act number 38 of 2014, right. So, can he purchase land? The answer is no, he cannot purchase land. The reasons are because he is a foreigner, as a person he cannot purchase land. Also, he is the sole shareholder of his company, right, of his company which is CC. So, even the company cannot purchase land in its name, right. So, those are the two things that you have to emphasize in this, right. But if at all the company needs to purchase shares, so then more than 50% of shares of the company should be owned by locals, right, and the foreign shareholding has to be less than 50%. Answer for part B, they are asking what the Companies Act states regarding the financial statements of companies such as CC. So, when it comes to companies such as CC, in the sense companies which have more than 50% of shares. So, there the company secretary has to submit the financial statements of each calendar year to the registrar of companies, right. Financial statements should be delivered, and in each calendar year, because the registrar of companies has to ensure that the foreign shareholding is less than 50%, right. And and also this even though it is an overseas company, the financial statements should be in the official languages of Sri Lanka. It has to be either in Sinhala or in Tamil, or it can be in English as well, right, and it is a must to be submitted. So, if at all the shareholding, let us say, is below 50%, then and if it has purchased land in Sri Lanka, then the company secretary has an obligation every 6 months to give a certificate or give a confirmation to the land registrar where the land is located that the shareholding is less than 50%. So, that sort of confirmation has to be given by the company secretary to the land registrar where the land is located, right. So, that is the key takeaway of this question. So, let us move on to the last section, that is section 3, right. So, see, they have given a little more information than you would get in section 2. So, therefore, let us look at the questions first and then go back to the description. Right. So, they are asking the types of directors, that L, R and M respectively, and then the responsibilities. Next one, they are asking whether PG can be appointed as a director. C is the legality of S's proposal, the effect and manner of passing a resolution. Then lastly, they are asking whether R's proposal is in line with the Companies Act. So, let us look at the scenario. So, you can maybe draw a small diagram in the margin, right, for a big description like this, right. So, Susi Private Limited, SPL, is a company incorporated under the Companies Act whose head office is in Colombo, right, head office is in Colombo and recently it was opened, a site office was opened in Vayangoda. As most of its directors are executive directors, SPL's board meetings have been shifted to the site office, right. But the shareholders of SPL, all members of the Pereira family of Colombo 15, are finding it difficult to attend shareholder meetings at the site office as they are based in Colombo, right. As a solution to this situation, Shehani, a directress, has proposed to pass circular resolution in lieu of meeting in future instead of conducting physical meetings of the shareholders. Additionally, Ramani, the accountant, so S is a director, right. Ramani is an accountant, right, has submitted a proposal to reduce SPL's stated capital through a board resolution, right. Now, this is a different scenario about the resolution and the accountant, then about the accountant, right. So, she has brought in a proposal to reduce the stated capital. Then also they are saying the shareholders are also interested in making the following new appointments. So, they are going to appoint some directors as well. So guys, before we finish, just want to let you know that on the chat we have put the link to the Telegram group and also to the WhatsApp group. So you can join those groups, and if you have any questions you can ask me, because I will also be a part of that particular group. And also make sure that this session is in cooperation with the Big Four. So go to their website or their Facebook page and give them a like as well, right? Okay, so just want to remind you that, and let's look at this question. So yes, Ramani is an accountant, and now they are also looking at the appointing of both R and a well known freelance corporate consultant, Mr. Mendes. So that is an R. R is the accountant obviously, and M is a freelance corporate consultant, right? Then there is PG, Prasad Gamage, who is only a 17-year-old YouTube influencer, right? Let's look at the questions now. Yes. Explain what type of directors R and M respectively. So R is a well-known freelance corporate consultant. R is the accountant. So if at all she is appointed, she is an executive director, because she is in the management as well. So since there is an employment contract between R and the company, she will only become an executive director. He can't be a non-executive director, because to be a non-executive director you can't be an employee of the company. So since R is an employee, right, since she is an employee, she will be an executive director, right, executive. Then what about M? M is a freelance consultant, right? Since M is he's only a freelance consultant, right? He's in the capacity of a consultant and not an employee, right? Non-employee. So therefore he will be a NED, or a non-executive director. So when you are explaining these types, you have to give a description, because there is 8 marks. So you have to give the definition of who an executive director is. So executive director is an employee. He is also an employee of the company, and there is a contract of employment between the company and that particular person who is going to be appointed as the director. So therefore he is executive. A non-executive director is not a part of the executive team or the management team of the company. So they are not engaged in the day-to-day management, whereas executive directors are involved in day-to-day management. So they will only be, NEDs or the non-executive directors will only be involved in making certain decisions of the company, right. The next part B, explain per the Companies Act whether PG can be appointed. PG, the issue is, to be appointed as a director you have to be a person who is above 18 years, right. So according to the Companies Act, a director has to be a major, not a minor, so above 18 years, and this is stated in section 202. So since PG is only 17 years old, he cannot be appointed as a director, right. Part C, explain the legality of S's proposal, the effect and manner of passing such resolution. So S wants to pass a circular resolution. So yes, a circular resolution is as legal as a normal resolution that can be passed in an AGM of shareholders, right. So when a circular resolution is passed for it requires to be passed as a special resolution, then 85% of shareholders should agree to the resolution, right. So it will be in lieu of the meeting, and it will have the same effect as any other resolution, but only thing is when the circular resolution is passed by 85% of majority of shareholders, it has to be circulated among all the shareholders, those who didn't agree as well, and it has to be and it has to be acknowledged in the coming AGM, right. And within 5 working days of that resolution being passed, every shareholder should get a copy of that resolution, right. So, you have to also remember that always the articles of the company will govern how a circular resolution needs to be passed, and it has to provide for the circular resolution. So, whenever the shareholders cannot get together in a meeting, they can pass a special resolution, a circular resolution by way of writing. Okay. So, every shareholder has to sign on it, right. It has to be in writing, it has to be signed. They can place the electronic signature as well. So, then lastly they are asking, explain whether R's proposal is in line with the Companies Act. So, what has R proposed? So, she has proposed to submit a proposal to reduce SPL's stated capital through a board resolution. So, is it in line with the Companies Act? It is not, because now what is she referring to? She is saying it has to be passed by a board resolution. No, it has to be passed by way of a special resolution, because this is where it's affecting the shareholders, right. So, board resolution is a resolution where the board of directors will pass it, right. If there are 5 or 10 directors, they will pass the board resolution. But if we want the consent of the shareholders, especially for major decisions of the company, then a special resolution should be passed, right. So, for a special resolution, 75% of shareholders should agree, and if the special resolution is passed by way of a circular resolution, then 85% of shareholders should agree on the resolution, right. So, then let us look at the last question, which is question number 7. So, here it says Sunila Gamlat is a financial consultant by profession. Her immediate family members are carrying on a furniture business under a company named Frington Furniture Company, incorporated under the Companies Act of 2007. EFC's articles have restricted the maximum number of shareholders it can have. So, there are restrictions on the company's articles, as its shares are closely held by the members of SG's family. So, this is like a family business that they are talking about. Now, SG has been invited to become a shareholder in the company. So, Sunila Gamlat SG is a financial consultant by profession, right, but she does not necessarily have any connection to EFC, which is a family business, but now SG has been invited to become a shareholder in this company. She has also got to know that sometimes the affairs of EFC are mismanaged, and also that EFC is not too well known in the market, right. So, this is what SG knows about EFC in the market, EFC's position in the market. But SG also loves a challenge, plans to accept this invitation to become a shareholder of EFC, and thereafter plans to propose the following to the other shareholders. So, she has some proposals. So, one is to change its name to a more commercially marketable one, and for EFC to change its nature of business to a more profitable one. So, they are going to take a person who is outside of the family business in order to see whether the company can be commercially marketable, right. So, let us see what are the questions they have asked. So, first one they are asking, identify the type of company EFC falls under the Companies Act. So, they are asking what is the type of company, right. So, the type of company here, it's obviously a private limited company. So, the private limited company can have a maximum of 25 shareholders. So, you have to make the assumption here, since it's a family business, the number of shareholders will be very limited. So, obviously, it's a private limited company. It can't be a listed company or a public company, because the number of shareholders is very low. It can't be, obviously, it's not a limited by guarantee company, because it's not in relation to charitable purpose or anything like that, and it doesn't have members itself, it has all family members, right. Then they are saying explain two of the main characteristics attributable to such company. So, they are asking what are the characteristics of a private limited company. So, as I told you, one characteristic is that the maximum number of shareholders can be 50. Yeah, I told you 25 before, it's actually 50, right, 50 shareholders, and maximum is 50, and it can't sell shares to the public. They can't sell shares to the public. It can't be listed for the public to purchase shares, right. So, maximum number of shareholders is 50, and and also there is a restriction that they can't publicly list the shares for public to buy the shares, right. Then the next one is they are asking explain the steps to be followed as per the Companies Act in order to change EFC's name as proposed by SG. So, when the company's name is being changed, the shareholders, then also the directors, all of them get involved. So, you need to have first you need to obtain a special resolution which is passed by the shareholders of the company, and with that you can submit to the registrar of companies, because you need to get approval of the registrar of companies for a name change, right. So, also within 10 days of the name change, again you have to give notice to the registrar. So, to change the name also you have to get approval of the registrar of companies, and after the name change happens, you have to again give notice of the change to the registrar of companies. And then you have to also give public notice of the name change, and the public notice must specify certain things. They have to say, the notice has to identify what was the previous company's name, what was the previous business registration number of the company, and currently what is the new name of the company, and what is the new address of the company, and also if there is a change in company number, then maybe that also has to be mentioned in the notice to the public, because the public has to be notified of the change of the company's name, right. Then again, now they already asked about mismanagement before, but again they have asked what is meant by mismanagement of a company. So, who can mismanage a company? It is the management of the company, or it can be shareholders, or it can be directors as well, right. If they are mismanaging the company, or if they are acting against the interests of the company, the best interests of the company, then that is what you call as mismanagement. But unfortunately, there is no definition for mismanagement in the Companies Act. So, it goes by how it is decided by the courts of Sri Lanka, right. So, the courts will decide, they have to look at the facts of the case, they have to look at the situation that is at hand and decide whether it is mismanagement or not, right. So, if the company's affairs are being conducted in a manner which is prejudicial to the company's interest, that is what is basically identified as mismanagement by the courts of Sri Lanka, right. So, that is what you have to write here. And then for the last part, which is part E, explain the type of transaction the change proposed by SG in 2 above falls under, and what EFC must do to enter into such transaction. So, in 2, what has she suggested? She has suggested to change the nature of the business, right. So, earlier we talked about changing the name of the company. Now, they are talking about changing the nature of the business. So, what is here? It is about basically a major transaction is going to happen, right, because now when the company's business is changed, it is going to be more profitable. So, which means now this will actually fall under major transactions, right. Changing the nature of the existing business, it will fall under the scope of major transactions. So, I hope you know when there are listed, when it comes to a listed company, it should have certain committees, right. So, if it is a major transaction that is going to happen, then the committees have to take the decisions. But for a private limited company or for a family business like this, it is not necessary. The family itself will take the decision, right. So, since this will fall under a major transaction, they have to first get approval by way of a special resolution, and then you have to then thereafter you have to get, when the special resolution is passed, you have to get the consent of, you are getting the consent of all the shareholders when the special resolution is passed, and you have to inform it to the registrar of companies as well. Even though you don't need the objects of the company to be included, whenever there is a special resolution that is being passed, you have to inform that to the registrar of companies. So, there is a particular form that you have to submit to the registrar of companies when there is a special resolution. So, even though the business, the nature of the business, what is being transacted, what sort of transactions is happening, does not necessarily matter to the registrar of companies. Whenever there is a special resolution that is being passed, that has been passed by the shareholders, that has to be informed to the registrar of companies, right. So, when you are informing, it is obviously electronic, you do not have to physically go there and hand it over, you can always upload it to the online portal of the registrar of companies, right. So, the type of transaction here, it is a major transaction, and to enter into such transaction, you need the approval of the shareholders and also the directors. So, ideally it has to be a board resolution and also a special resolution of the shareholders. So, this is basically what I had to discuss with you with regards to the 2024 paper. So, all in all, I hope all of you all got an idea of how you should attempt the paper, like how you should face the paper, how you should study for the paper, and also finally how you can get more marks and what you should write on the paper as well. So, by discussing this, I hope you understood what sort of areas are mostly tested from you, right. So, remember they test always on foreigners, whether the foreigners can buy lands in Sri Lanka, when a foreigner has high shareholding in the company or more than 50% of shares is held by a foreigner, then can they purchase land in Sri Lanka, right. So, that comes under land restrictions on Alienation Act, and they test you on Foreign Exchange Act, inward investment account, and outward investment account. So, these are like compulsory areas that they will question you on. And also remember the types of companies, companies limited by guarantee, the directors, the types of resolutions, the dividends, distributions, then the qualifications to become a director, when does a director can be removed, what are the instances that a director can be removed, right. So, these are the main areas that they can test you on. So, keep that in mind and get ready for your paper, be familiar with the areas, go through the past papers and then study. When you are studying, when you are, first go through the past papers, then you study and again attempt the paper. And if you do not remember a particular area, go back to your study text, study it again and come back and answer the paper. So, always go in a question and answer basis, because Like I always tell you, law is a very vast subject and you can't study everything in it because you have other subjects as well. So keep that in mind and pick the areas that you must remember, because as we have discussed throughout the revision classes, there are areas which you can't miss out. You have to study those, right? Especially like incorporation, directors, types of companies, mandatory for you to know, right? So remember those areas very clearly, very precisely, and then you can answer the paper successfully. Look at the mark that is allocated to you, especially in essay type questions, and then make the decision as to how much you should write, right? Look at the keyword, whether it's state, explain, discuss, what they have asked, and write accordingly. So MCQ questions, pretty straightforward. You have to select the correct answer. So read the questions, read the answers properly for MCQs. So that's it for today. Thank you very much for joining in. If you have any questions, you can ask. Thank you very much, everyone. So if you have any questions, you can even put on the chat. So that's it for today, and I hope there are no questions as well, since I don't see anything on the chat or anybody who wants to ask a question even. Okay, then thank you everyone. Thank you Big Four for collaborating with Infinity Space and giving this opportunity for me. So thank you so much for joining in today.